Mr. Deputy Speaker, first let me thank all the members who have spoken for their considered views on the bill and also for their general support of the bill and its policy objectives. Members have raised a number of points which fall into broadly three categories, and I will endeavor to respond to them in turn. The first relates to the importance of international cooperation in combating terrorism financing. Second relates to the need for an effective enforcement regime. And finally, members have also raised questions on specific provisions in the bill. Ms. Fumiha and Professor Fatima Latif spoke on the need for countries to work closely together to combat terrorism financing. Specifically, Professor Fatima asked about the cooperation mechanisms among countries that are parties to the International Convention on the Suppression of Financing of Terrorism. The Terrorism Suppression of Financing Act, TSOFA, includes provisions that allow the Convention to serve as a basis for mutual legal assistance under our Mutual Assistance in Criminal Matters Act and for extradition under our Extradition Act. We are therefore able to make and accommodate requests for mutual legal assistance and extradition involving other convention parties. Our law enforcement agencies work closely with their foreign counterparts to share best practices and exchange information to investigate and disrupt any terrorist plot or terrorist financing activity. For example, the Suspicious Transactions Reporting Office, STRO, in the Commercial Affairs Department has signed Memoranda of Understanding with its Financial Intelligence Unit counterparts in other countries such as Hong Kong, Japan, Malaysia, United Kingdom, and United States for the purpose of combating money laundering, terrorism financing, and related criminal activities. These MOUs allow financial intelligence units of different countries to share financial intelligence with one another. Regarding Professor Fatima's question on the processes to deal with funding from an overseas entity, it is an offense under the TSOFA to deal with funds belonging to terrorists or terrorist entities, regardless of where the funds originate, locally or overseas. If the financial institution detects funds which they know or have reason to believe may be from terrorists or terrorist entities, they are prohibited from dealing in such funds and are required to make a report to the law enforcement authorities for investigations to be conducted. Madam Speaker, the transnational nature of the terrorism threat makes cooperation across countries all the more important. And we are fully committed towards working with the global community in the fight against terrorism financing. While Singapore is not directly involved in the review of Al-Qaeda sanctions by the United Nations Security Council, which Ms. Sylvia Lim raised, we will review and refine our regime in line with new developments as a member of the UN and as a major financial center. And that includes any enhancement of sanction measures by the UN Security Council. Mr. Desmond Lee has also asked how we fared relative to other countries in tackling terrorism financing. Singapore did well at our last Financial Action Task Force FATF mutual evaluation in 2008. Singapore was rated either compliant or largely compliant for the FATF special recommendations on terrorism financing. Our results were on par with those of the United States and the United Kingdom. And the amendments in this bill will further strengthen our compliance with FATF standards. Let me now turn to the enforcement regime and its efficacy. Domestically, we have also put in place a robust regime against terrorism financing and money laundering. As various members, Mr. Desmond Lee, Professor Fatima, and Ms. Fumiha had mentioned, having tough laws alone is not enough. We must be able to detect and enforce against violations, as well as engage key stakeholders in various sectors to raise awareness and strengthen capabilities. Section 39 of the Corruption, Drug Trafficking and Other Serious Crimes Confiscation of Benefits Act, CDSA, requires any person to file a suspicious transaction report if he has reasonable grounds to suspect that any property is linked to criminal conduct and such suspicion arose in the course of employment or business. This requirement applies to all persons in Singapore, including financial institutions and entities in other sectors. This would also apply to any person working in the Freeport facility in Singapore, highlighted by Ms. Fu. Mr. Arthur Fong and Ms. Fu spoke on the important role that our financial institutions play in preventing and detecting suspected terrorism financing activities. And we fully agree on the need for a mutually reinforcing approach to fight against the scourge. Besides the filing of STRs, financial institutions are also required by the Monetary Authority of Singapore to perform ongoing monitoring of their customers. MAS conducts regular on-site inspection and off-site supervision to ensure compliance. Financial institutions which fail to put in place the necessary measures are subject to a range of supervisory actions, including actions for serious breaches. Ms. Fu made the point about a risk-based approach and being more targeted, and we agree with that, because a one-size-fits-all approach does not work when you're talking about risk management and transactions monitoring. Instead, the Monetary Authority of Singapore supervises the financial institutions, including money changers and remittance agents, to assess that the robustness of their systems is commensurate with the scale and complexity of their operations and the risk profiles of their customers. So it's a calibrated approach, and it takes into account the risk. MAS also provides supervisory guidance to financial institutions to rectify any weaknesses, including in their processes for STR filing. Regular outreach is conducted together with industry partners to raise awareness. The STRO has been engaging various persons and entities that have filed STRs on an ongoing and regular basis to provide feedback on the STR. So this is part of the education process that several members spoke about. Besides financial institutions, STRO also works through business associations and regulatory bodies to broaden the reach to businesses and professions from other sectors, such as real estate agents, lawyers, accountants, and jewelers. And the appropriate relevant regulatory agencies will continue to review and enhance the regulation of these sectors to mitigate the evolving terrorism financing and money laundering risks. But the outreach is an ongoing effort. And these efforts have resulted in more suspicious transaction reports being filed by industry players. In 2012, STRO received nearly 18,000 STRs, of which more than 2,000 were filed by non-financial institutions. STRO has also assessed that the quality of these reports has improved over the years. And we will continue the outreach efforts to the various sectors to strengthen the STR reporting regime. Mr. Desmond Lee and Ms. Sylvia Lim asked about the number of investigations and convictions for terrorism financing offences. We have investigated a number of cases, but there have not been any prosecutions thus far. This is because most cases involve terrorists who were self-financed, and the issue of third-party financing did not arise. Swift action was taken to detain the terrorists, and as a matter of course, where there is suspected financing activities, provisions under the CPC may be used to seize the funds. Once it is confirmed that it involves terrorist activity and the person is deemed a terrorist, Section 6 of the TSOFA applies to prohibit dealing in terrorist assets. Notice is then served on institutions and counterparties not to transact with the terrorist, which essentially freezes his assets. Mr. Speaker, Singapore operates a rigorous regime against terrorism financing and money laundering. The proposed amendments in this bill, such as the increased penalties and new provisions to protect informers and criminalize tipping off, will further strengthen our enforcement regime against terrorism financing. Let me now turn to specific questions on the bill. Ms. Fumiha asked whether the legislative framework to counter terrorism financing and money laundering, which is currently found in two different acts, the TSOFA and the CDSA, should be simplified to reduce possible inconsistencies. Madam Speaker, the objectives of TSOFA and the CDSA are somewhat different. CDSA focuses on depriving criminals of their proceeds from a criminal offense. The TSOFA, on the other hand, can be preemptive. It seeks to cut off the resources available to terrorists so as to prevent the commission of terrorist acts in the first instance. While there may be some similarities, such as in terms of methods used to carry out money laundering and terrorism financing, there is merit in having these two different legal regimes, which allows us to have a more calibrated and targeted approach depending on the nature of the offense. The Ministry of Home Affairs is reviewing the CDSA, including the penalties provided within the Act, and where it is necessary to align the provisions, certain provisions or penalties, with TSOFA, we will do so. Ms. Fu commented that it may be difficult for the bank to establish whether the suspicious transaction of funds is for terrorist financing or other criminal activities, and therefore whether to make a report under TSOFA or CDSA. In practice, we would just require one report from the institution. The authorities will then follow up with the investigation and assess whether an offence under TSOFA or CDSA has been disclosed. Professor Eugene Tan was concerned that the definition of terrorist in the Act was too broad. On the other hand, Ms. Sylvia Lim has also asked if there are concerns that certain terrorist groups are not listed and identified specifically. The Act defines a terrorist to include any person who commits, attempts to commit, participates in, or facilitates the commission of any terrorist act. It also includes any person set out in the first schedule of the Act. So even if he is not in the schedule, if he fits the definition, then he is caught by the Act. Mr. Speaker, our definitions of terrorist and terrorist act are consistent with the legislation of other jurisdictions such as Hong Kong, and it is also in line with the International Convention on the Suppression of Financing of Terrorism. So we have taken reference from the international standards and also some comparable jurisdictions. The provision to specify persons as terrorists in the first schedule is intended to enable us to meet our international obligations under the UN Security Council resolutions, which require financial sanctions to be imposed on individuals and entities designated by the UN Security Council committees. This schedule is currently set out in the United Nations Anti-Terrorism Measures Regulations and will be moved to the TSOFA with the consolidation of the overlapping terrorism financing provisions. This bill does not change the existing definition of terrorists in the Act. Mr. Dinakaran suggested expanding the definition of terrorist act in the TSOFA to criminalize the act of planning or conceptualizing a terrorist threat. TSOFA does not criminalize terrorist acts, but the financing of terrorism. We've got to be clear about the intent of the Act. The commission of terrorist acts is criminalized under other statutes, such as the Terrorism, Suppression of Bombing Act, Hostage-Taking Act, and Maritime Offences Act. The planning and agreement to commit such acts would be an offence of criminal conspiracy under Section 120B of the Penal Code. Mr. Desmond Lee, Professor Eugene Tan, and Mr. Dinakaran also asked whether the penalty for terrorism financing offences should be set higher than for money laundering offences, given the severity of terrorism acts. And I appreciate the sentiment behind the questions and the proposals. The penalties for the terrorism financing offences are in line with those of other jurisdictions, the penalties that have been proposed. For example, Canada, Hong Kong, Germany, Switzerland, and United Kingdom impose a maximum imprisonment term ranging from 5 years to 14 years. So there is a range. The member mentioned the US, I think, where we talked about 20 years. So there's a spectrum. and we think 10 years is a reasonable reference point at this stage. The bill will also raise the maximum fine for terrorism financing offences to the same level as for money laundering offences, that is 500,000 in the case of individuals and 1 million in the case of entities. This is a significant increase, 5-fold for individuals and 10-fold for entities, and it should provide a strong deterrence. I recognize the point that Mr. Lee made about corporates, and the sum of 1 million may not be significant, but I think we have to look at it in totality. And I think once an entity is the object of such action, the reputational damage and the limitations that will therefore result in its operational capabilities will, I think, also have a significant sobering effect. We have made this move to significantly enhance the penalties, and we will monitor the effectiveness, and we are not averse to the idea of reviewing these penalties if that's necessary. Besides increasing penalties for terrorism financing offences, the bill also seeks to strengthen our counter-terrorism financing regime through the inclusion of the new Section 10A to protect informers. Professor Eugene Tan was concerned that Section 10A may make it difficult for the accused to mount a defence. Mr. Speaker, we need to strike a balance in the public interest between giving the accused unlimited access to all available information for his defense and protecting informers so that they will not be afraid to provide much needed intelligence to prevent terrorist attacks. This does not absolve our enforcement agencies from conducting proper investigations and gathering the requisite evidence to prove all the elements of the offense. But the key point here is this balance is an important one, and this bill seeks to strike a balance in the context of what we have experienced in Singapore today. Mr. Hari Kumar also spoke on the circumstances that would permit disclosure of the informer's identity and safeguards available. Disclosure is permitted in limited circumstances, which is specified in subsection 3. Disclosure is allowed in criminal proceedings if the court is satisfied that an informer had willfully made a material statement which he knew or believed to be false. In other proceedings, disclosure is permitted only if the court is satisfied that justice cannot be fully done between the parties without the disclosure. So the courts do have the discretion. This exception is intended as a safeguard against injustice resulting from protecting the identity of informers. In such situations, the court will assess whether to lift the protection after weighing the interests of protecting the informer's identity. This is an established system. We have experience in this, and it has generally worked well for us. Other statutes, such as the Misuse of Drugs Act, contain similar provisions to protect informers. Professor Eugene Tan was also concerned about witnesses providing information which they knew or believed to be false during court proceedings. Although the TSOFA itself does not have a specific provision to criminalize such acts, they can be dealt with under the Penal Code. Under Section 193 of the Penal Code, for example, if a person intentionally gives or fabricates false evidence in a judicial proceeding, he is liable to a fine or an imprisonment term of up to 7 years or both. Let me move on now to comments from members on the new Section 10B, which criminalizes tipping off that prejudices an investigation under TSOFA. Mr. Hari Kumar has raised some questions on the scope of the legal privilege in the new Section 10B. As Mr. Kumar has pointed out, and as the Minister for Law can attest to, the scope of this privilege was explained when the Evidence Act amendment was moved in 2012. The reasons for limiting the scope of the privilege apply equally to the use of legal privilege as a defense to the offense of tipping off. Given the gravity of the offense of terrorism financing, we see no justification in this instance for a wider defense, especially since we want to safeguard against abuse of legal profession privilege. The bill also refines the exemption provision in Section 7 to support our terrorist rehabilitation efforts. Mr. Hari Kumar suggested that Section 7(1) should be drafted more narrowly to spell out the precise circumstances in which an exemption may be granted. Under the general exemption order for basic expenses to be made under Section 7(1), the definition of basic expenses will be clearly specified so that only transactions such as payment for foodstuff, rent, mortgage, medicine, and public utility charges that fulfill this definition will automatically be exempted. Outside of the general exemption order for basic expenses, there may be other legitimate circumstances that warrant an exemption order to be made. It's not quite feasible to spell these out precisely or comprehensively, given that the nature and type of such transactions or activities may vary and evolve over time. But let me assure the House that our agencies will carefully examine the merits of each case before granting any such exemption. As for the question on revoking of exemptions, an exemption order can be revoked by the Minister. If an exemption order has been breached, then the exemption may not apply and the person exempted will be guilty of the offence for which he is exempted. Mr. Hari Kumar and Ms. Sylvia Lim asked about the safeguards to ensure that funds will not be channeled towards terrorist activities. Again, I want to assure members that there are procedural safeguards in place. Our law enforcement agencies will conduct a thorough investigation at the point of application for such an exemption to ensure that the transaction is for a legitimate purpose before any exemption is granted. And these exemptions can and will include conditions and requirements such as regular reporting. Our agencies will also monitor the exempted transactions or activities to ensure that the property and services are utilized for the declared purposes. The government works closely also with the community on the rehabilitation of terrorists and to counter the spread and influence of extremist ideology in Singapore. So Professor Eugene Tan asked whether persons who are found guilty of terrorism financing offences will be required to undergo counselling. All terrorism-related cases, including terrorism financing, will be investigated thoroughly, and subjects were found to be ideologically indoctrinated to support terrorism activities will be encouraged to undergo counselling as part of their rehabilitation. There's also the question raised on levers to block access to and funding of websites that promote radicalization. The TSOFA makes it an offence to provide funds for terrorist purposes, which would include the funding of extremist websites. Under the Broadcasting Act, MDA is able to require Internet service providers to block access to such sites. Mr. Speaker, I believe I have substantively covered the points that have been raised by various members in the course of this debate. And I want to stress that terrorism continues to pose a significant security threat both globally and in the region. We in Singapore have consistently taken a strong stance against terrorism. As a responsible member of the international community, Singapore is committed to supporting international efforts to combat terrorism, including terrorism financing. The proposed amendments will align our regime with the practices of other jurisdictions. It will also bring us into greater compliance with international standards, as well as strengthen Singapore's competitiveness and status as a trusted financial hub. And I urge members of the House to give your support for this Terrorism, Suppression of Financing Amendment Bill.